So my name is Sam Pekka. I'm a partner in Dallas's Weil office. My practice focuses on corporate transactions, so typically representing private equity companies and private equity sponsors, sponsor-backed companies, occasionally strategic entities. So I focus on energy companies primarily. That's been mostly oil and gas companies, but now moving into more renewables and energy transition as well. So I'll let my colleagues here introduce themselves in just a minute, but I'm going to just introduce the topic really quickly. And so what we're talking about is specifically contracts where the parties have made an attempt to negotiate a circumscribed limit to their liability. And so that can come up in a couple of ways, right? You could have a full walkaway deal where the parties have decided that once a transaction closes, all reps and warranties and pre-closing covenants die and no one's going to make a claim against the other party. You could have something more complicated where you have a full indemnification provision and the parties have agreed that all claims for breaches are going to be funneled through this indemnification provision that has limits on minimums for claims, caps on aggregate claims, time limits for when claims can be made. And then you might be talking about something that's less than something so comprehensive. So just a limitation on the types of damages that a party might be entitled to, or limitations on time that claims can be made. So all those things are pretty typical. And what's also probably seems pretty typical is to put an exception on there that says except in the case of fraud, lowercase fraud undefined. And so what we're trying to get at today is to talk a little bit about how large that exception actually is in ways that you can think about defining it further to more specifically narrow the gaps that creates. So when I started practicing about 11 years ago, that was really common to see that exception with just the lowercase fraud. And parties were generally okay with that because people generally feel they're comfortable that they're not committing fraud. And it's hard to argue against a fraud carve-out because you get the responses, right? Fraud is fraud. Are you trying to defraud me? Things like that. So it's difficult to negotiate against it. But in our space, it's becoming more and more common to have that specifically negotiated in some of the ways that we're going to talk about here in the slides. And that's largely been driven in part by some scholarship that's come out of the Weil Dallas office through one of our retired partners, Glenn West. And we'll provide you some links to his articles as well because he's got some good background there. And he is a colorful writer, more colorful a writer than we are speakers, I think. So with that long introduction, I'll let Liz and Luke introduce themselves.
Hi, I'm Liz Ryan. I am a trial lawyer in Weil's Dallas office. I joke that I'm here because I see the back end when no one asked any of these questions and things have gone horribly wrong and we're now suing over what is fraud, what do the parties understand, what do they mean by this contractual term, what do they intend to carve out, what did they not. And so part of our goal today is to help you, as much as it's bad business for me, it's good business for you to never have to need me, right? And so we're trying to help you figure out questions to ask yourself as you're doing these deals and just some concrete contractual language that you can take away from this and start implementing in some of your deals to prevent litigation and fraud claims after the fact. Luke?
Yeah. Hey guys, I'm Luke Harley, first year associate on our private equity team along with Sam here. Just graduated law school last May and joined the firm in October. Come from Pennsylvania area originally, so first time in Texas. Having a great time here, practicing with the firm, and looking forward to talking to you all today.
Great. I'm going to see if I can work this.
Yep.
Okay. So the first question we pose is, we don't commit fraud. Why should we care about this? And the counter that's one thing that we hear. And on the counterpoint, when you try to raise this with a counterparty, is things like, so what, you're telling me you want to defraud me, and fraud is fraud. We don't need to define this. And so those are some of the things that we'll talk about as we go through. And we also have an example negotiation that we, if we have time at the end of the presentation, we'll run through that. And you can see how good of actors we are. But I will say that most people who, once you start working through the issue and talking about the specific points in the fraud definition that we're going to go through, most people actually do become amenable to working through the issues and understand what you're getting at. Okay, so these are reasons why you should care about the fraud definition. I just want to make sure. Okay, so first of all, when parties negotiate a contract with limited recourse, they're generally expecting that their respective exposure is limited to those contractually negotiated parameters, absent some truly bad act. And most people are comfortable that they haven't committed such a bad act, and so the business teams really think that their exposures are limited to the contractually defined terms. So if a dispute arises and you end up in the world where someone is claiming fraud, you might be surprised, or your business people might be surprised, that in the case of fraud exception is broader than just really bad acts. Fraud can be based on, and we'll get into this more later, but not just knowing misrepresentation, but reckless unknowledge of whether a rep is true. It can be based on even negligent misrepresentation in certain equitable circumstances, and it can be based on statements made not just in the contract, but things that were made by your representatives or business people or officers in the negotiations. So number 3, fraud is easy to allege and difficult to disprove. I think this is a big point, because even though you may be very confident that you don't commit fraud, your people don't commit fraud, once a dispute arises, you can imagine that the counterparty is likely to look for ways to claim fraud. And once they do, it's very hard to disprove that at an early stage because it's such a fact-intensive question. And so you end up incurring a lot of legal costs. You end up subject to a lot of discovery requests and things like that, where just having the claim survive and be litigated is a loss.
Yeah, and just to add there, the downside risk too is that, Sam just pointed out, right, you're not going to get a fraud claim kicked early in the case. The judge is most routinely going to allow the parties to take discovery, which is burdensome and expensive. It's burdensome on your team. It takes time away from their jobs. But fraud, unlike a classic contract claim, comes with a punitive damage attached to it, right? So fraud is almost always pled with a punitive damages request, and that's just an exposure that will set everyone's hair on fire inside your company.
And then these last 2 points we've talked about a bit earlier, but we'll talk about the various types of fraud in a couple of slides. And then the next, these are not only applicable to purchase agreements or merger agreements. This is really a concept that is growing in those types of contexts, but is something that's applicable anytime that you're making an exception to what is otherwise a contractually defined restriction on liability. And then 2 more points of particular importance. Number 1, individuals can be personally liable. So generally, right, an officer of a company is not personally liable for the acts that they take in the context of that engagement. But if they are personally involved in a tortuous conduct like a fraud, they can be named and personally liable for that. And so it's something that everyone should be very aware of. And the second is that a person can be personally liable for fraudulent acts of their agents. And so this goes back to thinking about whose statements could be the basis of fraud. In particular, if you have a complicated transaction where you have multiple employees, multiple officers, outside advisors all talking to your counterparty, the top, the people that you're negotiating the terms of the contract with may be comfortable that they haven't said anything that could be the basis of fraud. But you have to think about all of those people and all of the information that you've been sharing, and if there's anything in there that could be an assertion of a claim.
So as Sam previewed, there's a number of different types of fraud beyond just the knowing falsehood that everybody kind of thinks of that comes to mind when we're talking about fraud. And so some of these different types of fraud, the first one being common law fraud, which is what I just referred to. It's sort of the big one everyone thinks of, and this is a statement that's made with knowledge of its falsity, or if it's made recklessly without regard for whether it's true or false, such as making representation one way or the other when you don't have any basis for truly knowing the answer to that. As opposed to equitable fraud, which is a statement that can be based on, or fraud based on completely innocent statements or statements made with negligence. There isn't a requirement under equitable fraud for knowing falsity or reckless disregard of the truth. And then promissory fraud is the oral communication of a promise to do something in the future in which the promiser never actually intends to do. This is one that is of particular worth noting. We'll reference later on in the presentation a recent Texas Supreme Court case, but this is kind of an issue that came up there where there were some technical specifications, statements of work, and representations made within those statements of work were made where the promiser was later unsure whether they were going to be able to live up to the statements of work and the specifications that the client in that case needed. And so this is something that we think is a decent pitfall for honest miscommunications that can later lead to contractual fraud claims. And then the last one is fraudulent non-disclosure, which is a subcategory of fraud and occurs when a party has a duty to disclose certain information and then does not do so.
Yeah, just a couple of things to add to these. So on the common law fraud point, when we're defining fraud, one of the primary things that we're getting at is taking that first, or one of those elements, which is knowledge of falsity or reckless ignorance of the truth, and limiting that just to the intent, the knowing falsity. Then in equitable fraud, again, that doesn't require you to know that something is untrue. That may require, depending on what state you're in, some kind of special relationship between the person making the representation and the person claiming fraud. And your recourse there might be limited to rescission, so it's a little bit of a narrower case, but it is still a risk. And then on the promissory fraud point, the case that Luke was referencing, where we think that is very relevant to people is that the person being that was claimed to have defrauded the other side had made statements that when they were putting in a request for work that they could do certain tasks, and they knew that they couldn't do those, but they thought, well, if we get this business, we're going to learn how to do it. We'll get up to speed. We'll figure something out. And so I think that probably all business people do that sometimes to some degree, and it's sometimes innocent, and sometimes it's on a scale, like how risky it is to be saying that you can do something when you need to get up to speed on it once you win the work. And so that's one that I think when people say we don't commit fraud, it's like maybe you don't, but maybe we're doing something that's on this scale and someone could make a claim, and we don't want to even have a claim for this. And then fraudulent non-disclosure, the rules on that really vary a lot by state. But one of the elements there is that you have a duty to disclose. And so that duty to disclose can be based on a special relationship, like a fiduciary relationship or a confidential relationship. But in Texas, it can be a little bit broader than that, where if you start to make disclosure about something, if you make a partial disclosure, you may have a duty to make full disclosure about an issue. And so that can raise its head.
So one of the cases that we wanted to highlight is actually out of New York, and we'll talk both about Texas, New York, and Delaware law throughout this presentation because we find it's where most people tend to do business. And this is the case is Board of Managers of Surrounding Condominium versus Forrester, and it's talking about what it takes to support rescission, right? Which is you don't want your deal to be rescinded and go back to zero. So how do we avoid that? And what the court said is that in order for rescission, you only have to show a misrepresentation that induces a party to enter the contract, resulting in some detriment. And unlike an actual cause of action for fraud to seek damages, if the equitable remedy that you're seeking is rescission, you don't have to prove intent and you don't have to prove pecuniary loss. That's really scary, right? I mean, you're ending up in a situation where you might not face damages, but your whole deal gets unwound, not because someone intended to commit fraud and not because the other side suffered any loss, but but because there was actually fraud in the deal, right? And so the goal of this presentation is to arm you so that you leave with a little more comfort about, we need to think of what fraud is, right? Which is, we tend to think of it as an intentional lie, and look at it a different way. It's really so much more than that, and it does pose a risk to your deals if you're not thinking proactively about redefining fraud. So some of those questions that we should be thinking about as we're doing deals, these are the questions that I sometimes think about, why didn't anyone think of this as they were doing this deal on the back end, are what level of knowledge or intent is required to form the basis of a fraud claim? That's some of what we just saw, right? You may not actually have intended to commit fraud, and the other side may not need to prove that you intended to commit it in order to get the contract rescinded. So think about it. Are we really trying to guard against only intentional or common law fraud, or do we want to guard against a broader section of fraud, like fraudulent non-disclosure that we were talking about earlier? In our contract, whose statements or knowledge can form the basis of the fraud claim? Do we want to create a universe of people where we say these are the ones that we are concerned about making fraudulent statements, and outside of that universe is carved out, right? So are we talking about only what we call knowledge parties as a defined term? Are we talking about any employee within the company? Any employee, as Sam pointed out, that is part of the deal, maybe an outside consulting firm that you've hired, right? Who do you want to carve in and carve out of your fraud clauses? Who can a fraud claim be brought against? The contractual party? What if, for example, in a sales agreement, there are multiple sellers and only one of them is guilty of committing fraud? What happens in that circumstance? Do you want to contract and carve around a situation where you are one seller in a pool of many and you don't want to be bound by their misconduct?
And one of the places that comes up frequently is if you have an indemnification provision that caps damages or that otherwise limits damage claims, and all of the sellers are protected by those provisions, but all of those restrictions have an except in the case of fraud exception on them, then if one party has committed fraud, you're in fraud world, and none of those restrictions apply to everyone.
Yeah, you're in for a penny, you're in for a pound, right? And you want to avoid that. What about, is the fraud claim intended to allow for a tort claim, or does it trigger only indemnification? Are we not going to subject some or all limitations that apply to these fraud claims? So it really depends on the particular type of contract that you're doing and the particular risk that unwinding that deal or use of the indemnification may cause for that contract.
Right. And that goes, again, especially to indemnification provisions, where it's one thing to say that this indemnification provision is the sole remedy except in the case of fraud, and another thing to say this indemnification provision is the sole remedy and it has these limitations that apply except in the case of fraud. So that in the latter case, you're still in the indemnification provision, and you're seeking contract-based damages. They're just not subject to the limitations, versus in the first instance, you're outside of contract damages, you're into tort damages, and you're totally outside of the indemnification provision.
And again, tort damages comes with punitives,
Right.
Which you don't ever want to be there. One more, is the fraud carve-out intended to allow a tort claim or indemnification claim, like we just talked about, that are not subject to some or all of the limitations that would apply? And again, it depends on the particular contract that you're entering into, but you may want to carve out uses for that indemnification claim.
Right, and this might also be a good place to talk about the statute of limitations might be different. So
Yeah.
if you're bringing the claim under the contract and the indemnification provisions, you're still in the statute of limitations for breach of contract. If you leave the indemnification provisions, then you're in statute of limitations for the tort claim, which may not start running until there's a discovery of the issue. And so you may inadvertently extend the time for a claim for a long period of time.
Yeah, and to piggyback on that, I mean, so everyone understands, it's 4 years for both breach of contract and fraud. But your 4 years for breach of contract starts to run on the date the contract is breached. Your 4 years for fraud doesn't start to run until the fraud is discovered, which could take years after your deal closed. It's called the discovery rule, and it means that the injury doesn't start until the plaintiff discovers it. And so you don't want to end up in a situation where you're having a long tail on your deals because you've put yourself in tort land instead of in contract land. Finally, who can a fraud claim be brought against? The contractual party. What if, for example, in a sales agreement, are we going back? Are we somehow going back? I think our slides got messed up. Sorry about that, y'all. So we were talking about I think we've ended all of our questions. Do you have anything else that you want to add, Sam?
I don't think so on this.
Okay, awesome. Sorry about that, y'all. Now Sam's going to take you through some of the actual contractual language. So we'll start with what
Yeah.
normally appears in contracts and go from there.
So this is the typical formulation, right? Oh,
Oh, does someone have a question?
Just a quick question.
sure.
So it sounds like the boilerplate provision that's typically in every contract
Uh-huh.
that says all the reps and warranties and all the agreements that have been made with respect to this transaction are in this document.
Right.
There's no oral aspects to it. Make it sound like that's no protection at all against any of this.
That if you say except in the case of fraud, then that is no protection.
So his question was about the standard merger clause where it says, all of the representations and warranties that parties are making with respect to this deal are encapsulated in the document. You're not relying on any oral representations that have been made outside this agreement. It's standard contractual language that we're all used to seeing. Whether or not that is enough in this particular case.
Right. And going back, I think.
Now we're going to intentionally go back.
Yeah, sorry. So there's the question: whose statements or knowledge can form the basis of the fraud claim? And I think this is a good place to throw that in. That one of the ways that you see it defined often is to limit it to the reps and warranties in the contract, so that no statements outside of the contract can form the basis of a fraud claim. And that goes hand in hand with the provision that you're referencing that says, we didn't rely on any statements or reps made outside the contract. And so having those hand in hand really ties both ends of it. You didn't rely on anything, and there are no fraud claims outside.
But what the law says, and it's a good question, because what the law says is that merger clause is all well and good unless fraud was committed at the outset of the contract. And as we talked about in that, that Texas case, the parties never actually intended to perform the deal, right? And maybe they didn't have the capability to perform the deal and they puffed up their capability to get the contract. So in that particular case, whatever clause you've included is not going to bind the parties, and you're going to be subject to a fraudulent inducement or promissory fraud claim.
And so this is a kind of standard formulation of the exclusive remedy provision, except in the case of fraud, you're limited to the indemnification provision. So that's the way you typically see it formed. Here's a revision of that. And so what we've got is a definition of fraud, and then our exclusive remedy limits it to define fraud. And so a couple of aspects of this definition that you'll see is it's limited to intentional fraud. It's limited to the reps and warranties contained in the agreement. It has to be made with actual knowledge that it was false when made. It has certain other elements that are just elements of fraud. And then here's an even more robust definition of fraud. And I know that we sometimes expand these definitions beyond, to be a little bit overkill. But this has some important points. One, this includes knowledge parties. So you're limited to the knowledge parties who, in the contract. And so these are certain other provisions that go hand in hand with the definition of fraud. One is the non-reliance clause that we just talked about a little bit that says you're not relying on any statements or reps made outside the contract. The exclusive remedies provision that says, if you have an indemnification provision or other contractually defined remedies, that those are the exclusive remedies for a breach. And then a merger clause that says, there are no agreements or understandings outside the four corners of the contract, and everything is in the contract. So having those all together is the best way to, along with the defined term fraud, is the best way to circumscribe this liability. So examples of some of these provisions. Non-reliance, so I won't read the non-reliance provision to you, but this essentially says what we've been saying, that there are no reps outside the contract. Of course, if you put an exception for fraud on this, it makes it sort of meaningless because you're saying I didn't rely on anything outside the contract unless I relied on it and you lied about it. And another common mistake that's made in these that we see actually pretty often is they're often in the rep section, and they're often made by, it's the last rep in a party's rep section, and they say, I didn't make any reps to you other than the reps in this contract, and you didn't rely on them. And it's great if that party is making that as a rep to you, but what you really want is the other way around, where the other party is telling you, you didn't make any reps to me other than what's in this contract, and I didn't rely on any on anything outside this contract. And so it's very often reversed. And that rep, provides some additional protection, because if there's a fraud claim made, then you have a breach of rep claim, right? That they breached their rep that said that they didn't rely on anything, and now they're saying they relied on something.
And I can tell you, when you're in litigation, you definitely would like the option to have a counterclaim against a fraud claim. Yes.
Is on that last part, obviously switching the rep from, like, let's say the seller to the buyer on that front, which is what you were alluding to. I can just see the negotiation on that, the person saying, the buyer saying, I'm not going to give you that rep, and then that leads the seller to go ahead and drop a whole bunch more, reps in there.
Yeah.
Like the buyer may actually ask, like, practically speaking, how successful are you in actually getting that to shift over? I mean, obviously, I know the deal's got a lot of leverage and how that all plays out, but that sounds very kind of pushing water uphill.
We've been pretty successful in getting that in our contracts, and the concept, and this comes up a little bit in the mock negotiation if we get to it, but specifically that issue that the other party says, well, you gave me all this information in the data room, and you gave me, forecasts, and your people were giving us management presentations, and I want to make sure that you didn't lie to me in any of that stuff. And the response is, well, if anything that was said was so important that you're relying on it in order to enter into this contract, let's make that a rep. And if it's not that important, then you didn't rely on it, and let's not have lingering exposure for it. So this is some further language that you can put on about the nature of representations and warranties, and I think there's one other. So this definition really gets to trying to get to a true contractual nature of the representations and warranties, that we're not talking about truth and falsehood. We're just talking about a standard that we're contracting to, and you'll have a remedy if we miss that standard. So the example would be, I sell you my car and I say it's got a full tank of gas, and I'll give you $3 for every gallon it's lower than that. If we make that contractual arrangement, it really shouldn't matter if I know the gas tank is empty or I don't know how much gas there is. We've decided that you'll get the standard of full tank and a remedy if it's lower. That doesn't necessarily work in Delaware because there is a state-imposed exception, as well as in Texas, and so there are some limitations to how much you can get to this, perfect contractual arrangement. But we'll get to that here in a couple of slides. And then just some language around who is able to make representation. So going again to that representation that you haven't relied on anything outside the contract, a way to strengthen that is to say you'll also represent to me that you acknowledge that none of my agents and none of my officers had the ability to give you reps and warranties other than what's in this contract. And this is just a standard merger clause that we've all seen many times. So this is the sort of chain of scholarship that came out of our office on this that was put together by Glenn West. I think if you take a look at the titles there, you'll see that they're actually pretty fun reads. Luke, I don't know if you had anything to add on.
Luke is going to tell us what dog's breakfast means, right?
Yeah,
Yes, our prep session yesterday was spent researching what a dog's breakfast is. For anybody that's not familiar with the term, it's just a total mess. So if you want to avoid total messes surrounding your fraud carve-outs, want to make sure that they're tightly drafted.
And then state law imposed fraud carve-out. So we'll start with Delaware.
Yep. So now that we've been through some sample clauses, I figured it would be good to discuss kind of how these are treated in Delaware and then Texas afterwards. And so to borrow dog's breakfast again from Glenn, just because you've eliminated that potential there with a well-defined definition of fraud and a well-drafted non-reliance clause, that doesn't mean that you've completely removed yourself from the specter of a fraud claim. Under Delaware law, fraud claims can still be premised upon the express contractual representations that are set forth in the written agreement itself. And so a way to defeat this, and Delaware law enforces it, is an exclusive remedies provision, whereby, if it's well crafted, it would seek to limit the available remedies to just the contractual indemnification regime that's been bargained for as part of that agreement. And this is enforceable in Delaware for all types of fraud claims except for knowingly conveying a falsehood in those written representations, so going back to the typical meaning of fraud when we all think about it.
Right, and that's why it's, if you're in a Delaware governed contract, it's really sleeves off your vest. If you don't have to argue for no fraud carve-outs. You can argue for only intentional misrepresentation of the representations in the agreement, and that sleeves off your vest because the state's going to impose that anyway. The courts are going to impose that anyway. An interesting place that comes up is if you have a sales agreement, say a sales agreement for a company, and your sellers are not actually involved in the business, and the management team goes out and says some misrepresentations about the representations in the agreement. As long as your seller doesn't know that those are false, then the exclusion of those fraud claims is effective. So it's only if the seller actually knows that those claims are false, and so you can shift the burden or the risk of the management team's dishonesty to the buyer in that case. I think we go to Texas.
And then switching over to Texas, so this first slide that we have here just kind of sets forth the general rule on enforceability of non-reliance provisions. I wish in law school that I had cases like Italian Cowboy. That sounds a lot more fun to read. Love the name, but so the general rule that was set forth and restated in the recent Texas Supreme Court case that we've referenced, and we'll discuss a little bit more on the next slide. When sophisticated parties are represented by counsel and disclaim reliance on representations about a specific matter in dispute, such disclaimer may be binding, conclusively negating the element of reliance in a suit for fraudulent inducement. So generally, the analysis in Texas tracks along with how Delaware will treat non-reliance clauses. They will find them enforceable, but under Texas law, it's not quite as clear-cut, and there's necessarily a fact-intensive inquiry that goes into play. So the Supreme Court case that we've been discussing is IBM versus Lufkin Industries, and in this case decided in the terms of this contract were actually negotiated, going back to our boilerplate discussion. They need to actually be negotiated, and they need to have been discussed at the bargaining table as part of negotiating the entire written agreement. It can't just be something that nobody ever talked about. It had to be made aware to both parties. The party that's bringing the fraud claim has to be represented by counsel. The parties dealt with each other in an arm's length transaction. The parties were knowledgeable to the business matters, and the release language that is at issue is clear.
Yeah, one of the things that's interesting about this case is that the release language that was at issue had specific references to what representations were not made about. And so, it didn't just say there were no representations outside of this contract and I didn't rely on anything outside of this contract. It also had an including as to these issues. And it was one of those issues that came up. And so it was very clear as to no representations, no reliance with respect to that matter. And so it would be interesting to see how the Texas courts would interpret a general non-reliance, non-release, or non-reliance clause in this context. And so if there are specific issues that you're trying to address and you're under Texas law, it's best to be more specific if you can.
And let's spend a little bit of time talking about reps and warranties insurance, because everyone seems to be using it these days. And so let's talk about what it is and is not, especially in the context of fraud and indemnifications provisions. Just out of curiosity, how many people in the audience have used reps and warranties insurance recently on a deal? It's good. So as you know, typically indemnification provisions are kind of funded through escrow, right? There's 10 to 15% of your deal that's held back in case you need to take advantage of indemnification. And so reps and warranties insurance came on the scene to kind of replace that escrow and holdback in the event of needing to use indemnity. So typically, reps and warranties insurance will cover about 10% of the deal price. You'll have a premium that's generally equal to about 1% of your coverage, and then you'll have a deductible or retention amount as well. So reps and warranties insurance was intended to protect against losses that are due generally to the seller's breach of certain representations made in the agreement. So they can, depending on the specific deal, kick in some instances of fraud. But there are a couple important things to note when you're thinking about whether or not you really want to use reps and warranties insurance versus some of the more traditional contractual elements. So one of them is that it's not a black and white alternative to using your indemnification and using your traditional escrow, right? Because you're now dealing with an insurance company. You have to pay to access that money. And like with every insurance policy you've ever seen, there are going to be a litany of exclusions. And some of them are going to be deal dependent, right? Because depending on the size and the structure of your deal and the nature of the industry in which your deal is, that insurer might have done their own due diligence and carved out a significant amount of coverage that prevents you from being able to take advantage of that reps and warranties insurance that you've purchased for a not insignificant amount of money. It's only going to cover, as we said, 10% of that purchase price, right? So if it's not going to cover situations where your contract is rescinded, where your damages are far more than 10% of your purchase price. It's not going to cover a deliberate breach of the seller's covenants, right? It's not going to cover your traditional breach of contract claim. It's typically going to exclude reps and warranties that the buyer had actual knowledge of. So like Sam was talking about, when you do a deal and there's a lot of diligence and you spend time poking around in a data room and you know something, the insurer is going to say, I'm not going to cover you for something that you guys discovered during that diligence, right? Think about it I think of it in the context of patent litigation, right? If you acquire a company and you knew that they had breached a patent before you acquired them, and it turns out you also acquired a potential patent infringement lawsuit, the insurer is not going to cover any of that, right? They're going to say, you knew about that infringement when you purchased the company. It's clearly excluded from our policy. It's not going to cover forward-looking representations. So any representations that are made about future capabilities of the company, future investments that fall short, future revenue that falls short are not going to be covered. And it could also exclude certain types of losses. So it's not going to cover, punitive damages. If you've actually got a fraud claim that comes with punitives, your insurance is never going to help you recover any of that. There are of course, some benefits. It's why it's become so popular. It allows for, in some cases, the reduction or the elimination of the indemnity or the holdback, which can make the deal very attractive to the seller if you're the buyer and you're offering to pay for that. It can also sometimes speed up deals. People tend to think that I've got this sitting in my back pocket, so we can speed up some of the diligence process and worry less about that. And because it typically has a longer time period, your insurance may cover, 2 or 3 years, as opposed to your indemnity provision, which may only be a year or two. You would have a longer time period to discover issues with the deal and take advantage of that insurance. But it is something to think about. I think it's become, at least from speaking with people on the insurance side, it's become an all too frequent use because people think that they don't need to do the diligence and they don't need to do the deal work and they can just have it if anything goes wrong. But that is not the purpose of reps and warranties insurance. And if that's the way that your company or your friend's company is using it, chances are the insurer is going to deny coverage. And then you will have wasted, a lot of money for that.
And there is a common piece of the negotiation, right, is that once you move into a rep and warranty deal, it becomes much easier to get what you want on the reps and warranties because the seller knows that they're not personally standing behind them. And so they'll be more willing to give broader and, I guess you could say, riskier reps. Though the insurer will, and I don't know if you're going to touch on this, but the insurer will want access to fraud claims against the seller. And they're generally open to having those defined in some of the ways that we've talked about here. But you do have that exposure if you're using rep and warranty insurance.
And you should also know that if you get into a situation with your insurer where you're trying to take advantage of these reps and warranties, most of these agreements now include arbitration provisions which means that for people like me on the litigation side, there is not a lot of case law about how decisions between the insured and the insurers are coming out versus traditional insurance fights where you're fighting with your insurer maybe for litigation coverage or something else, which are typically litigated in court and produce a lot of case law that we can rely on. This is really kind of a secretive process that's happening behind closed doors, so it also makes it harder if you have to fight with your insurer later to have something reliable to go to the arbitrators with and say, this is how you decide decision because courts do it this way. You're kind of in a no man's land in terms of fighting with your insurer about taking advantage of that.
And so with that, we'll give you the mock negotiation here. Please forgive us. For the
Spoiler
acting.
alert, we are better lawyers than we are actors.
Yes. So this is in the context of one person representing a selling stockholder and someone representing the purchaser of a company.
Here, and I'll let you.
Okay.
scoot over. Should not be a literal arm's length transaction.
Sam, why'd you delete the fraud carve-outs in the exclusive remedy provision?
I don't want to introduce amorphous tort concepts into our contractual arrangement.
So you're telling me you want to be able to defraud me?
No, I'm telling you that I don't want to be accused of defrauding you based on something that you were told that I don't know about. And the only way to make that clear is to agree that all the reps and warranties are set forth in the agreement. And those are the extent of the factual predicates that you've been told.
But I was told a lot more than that.
If you were told something that was important to you, tell me what it was, and we'll consider making it a rep. Otherwise, it's probably not that important.
Well, what if I'm being lied to?
Assume that everything you're being told outside of this agreement is a lie.
What?
We have instructed our management team to be forthcoming and cooperative, but I'm not prepared to be responsible for anything that we haven't agreed to in writing as a factual predicate for the deal.
Okay, but what if I'm defrauded by something in the agreement?
Okay, on that we can agree, but only if we define fraud and we know whose fraud you're referring to.
Define fraud. Fraud is fraud.
No, it's not. Fraud can mean many things. We need to limit fraud to intentional and knowing fraud, and then only with respect to the reps and warranties that are actually set forth in our agreement. Fraud should be a knowing falsehood, not a lack of certainty or an inability to know with absolute certainty the truthfulness of a statement, such as that there have never been any environmental waste disposed of on this property. How can you actually know that? But we are nevertheless prepared to make that a rep as a matter of contractual risk allocation, just not for the purposes of a fraud claim. Unfortunately, the common law defines fraud much broader than that. But if you can prove that I actually lied to you about something we agreed in the written document is a factual predicate to this deal, you can have a claim outside the cap for that. But beyond that, we will not go.
Okay, but what if I'm lied to by management?
Is that the folks you're hiring?
Yes.
Okay. We're just shareholders here, and we're relying on management for all operational issues, and they are the ones putting together the schedules.
Well, as a matter of risk allocation, you should take responsibility for management.
We have. We've agreed to indemnify you up to the cap if any of the reps in the agreement, which have been vetted by management, prove inaccurate.
But what if they're lying?
If a shareholder seller actually knows the management is lying, then their lies are our lies. Abry makes that clear, as does DDJ in New York, so we can agree to that.
Where does this all come from? It's not market. No one else raises this stuff.
I'm happy to give you, if you want, some recent examples of publicly available agreements where this is in fact fully vetted as I'm laying it out. And so that's sort of the intro to these negotiations, and then you can get into the specific, throwing out a definition of fraud that has the different elements there and talking through each of the various elements that we hit in the slides.
Although I would suggest that you not tell the other side. Assume that everything outside this agreement is a lie.
Right. but that is, that is the basis.
But that's essentially what you're saying,
basis,
right?
Yeah.
Yeah.
It is. If there's something so important to you that you're relying on it, let's talk about it and maybe put it in the reps.
Does anyone have any questions? All right. Well, thank you all for your time. We really appreciate it.
Thank you.